In the Bakken oil fields in far northwestern North Dakota, oil riggers were busy at work standing up a new oil rig. Hall Trucking delivered material to the rig site. On November 2, 2022, one truck driver, having just offloaded his cargo, put his truck into reverse prior to exiting the job site. On that fateful day, the driver struck one of his coworkers who was standing on the ground behind the truck. When OSHA came to conduct an inspection and issued a citation, it issued a citation against Hall Trucking under the General Duty Clause. The parties debated whether Hall's lengthy safety plan was sufficient. We'll discuss all of the evidence in this case and what it means for your internal safety plans. I'm Manesh Rath, and this is the September 2025 edition of the OSHA 3030. Hello, everyone. I'm Manesh Rath. I'm a partner at Keller and Heckman, a law firm here in Washington, D.C. I've been practicing for 30 years, and I represent management in the field of occupational safety and health law. And I'm very fortunate today because I'm joined by my good friend and colleague, Ben Idzik, here at Keller and Heckman's OSHA team. What we're talking about today, Ben, is a case called the Secretary of Labor versus Hall Trucking Incorporated. And it just got a decision issued by an administrative law judge. Why don't we talk about what we'll talk about during today's episode?
Yeah, absolutely. As always, we're going to start with the facts of the case, the background, what happened in the incident, the inspection and citation. Then we're going to get an overview of what a general duty clause violation is.
Yeah, a real quick overview because we've covered this so many times in all of our prior episodes of the OSHA 3030. As you all know, the OSHA 3030 is a 30-minute update on impactful developments in OSHA law every 30 days. September, since this is the September edition, I should point out that this marks the beginning of a new year. We started this in August of 2013, so we're beginning probably our 13th year, I suppose. And we've been doing this every 30 days. All of our prior episodes are located on our website, khlaw.com. And since, as I was saying, we've done so many episodes on the general duty clause, we'll go through it this time quickly. Check out prior episodes. All of them are still relevant, educational, informative. After that, we should talk about what OSHA's allegations were against Hall Trucking.
Right. And off that, we're going to see what the defenses that Hall Trucking offered.
Right. And finally, having heard both sides, what the ALJ's decision was in this case, Secretary versus Hall Trucking.
That's right. And then I will enough, as always, with practical points of what employers should do based on
One
this case.
critical point that I would save for the end, I think is really important to anyone listening and staying till the end of the episode. A critical tip that comes out in the opinion from the administrative law judge. If you read it carefully, read between the lines, you'll see maybe one of the most important lessons that could be learned from the decision and how to mount an effective defense in a case like this. So why don't we get into it? The facts of this case?
Right. So Hall Trucking. Hall Trucking is a North Dakota-based heavy haul carrier that specializes in moving oil and gas drilling equipment. The company also performs other specialized moves, such as transporting windmill parts. So you think of the big trucks on the highways with the huge wind turbines attached to them, and also big natural gas compressors. But the primary business was the moving of the oil and gas equipment.
Everything from the rig to the pipes, all of the material that would be necessary to move onto a job site to stand up an oil rig. They have about 100 employees at Hall Trucking. Many of them are truck drivers, but they also have people on the ground, swampers and pushers. Swampers are the folk who help load and unload the material and to do the groundwork. Pusher would be maybe a logistics coordinator or a job foreman.
Exactly. Right. And the whole company is owned by a gentleman named Jeff Hall. And the supervision of the company is handled by Patrick Gorditz, who's one of the pushers that you mentioned, falls in that category. And he, and specific to this incident, which we'll discuss, he was responsible for planning and coordinating the logistics of the equipment move on this case.
So let's go back to November 2, 2022. On that day, Hall Trucking was in the process of moving drilling equipment onto the job site. And this is a job site near Epping, North Dakota, in the far northwest of North Dakota, as I said, in the Bakken oil field. And right where the Missouri River continues north and then bends to the west to continue towards its headwaters. And So this is near Epping, North Dakota, and the job site has a circular ring road around the center where the drilling site would be developed. And the folks at Haul Trucking have a traffic plan that trucks are to move around the ring, around the circumference of the specific drill site and unload equipment. But there are times where one truck arrives, and there are times where multiple trucks will arrive in a short time frame and create a wee bit of a traffic jam.
So during this, one of the equipment moves, a truck was backing up after unloading equipment.
So he'd finished unloading the equipment, and so he comes to a stop at his parking space,
Mhm.
so to speak, and swampers will come help and
Right.
offload the material onto the ground.
Mhm.
Later, it will be moved to the drill site. But the first order of business is to unload the material, let's say pipes,
Mhm.
and to move those off the truck and onto the ground. After that, and while they're doing that, by the way, other trucks are coming onto the job
Right.
site and sort of lining up behind this
Mhm.
truck, waiting for them to be offloaded.
Right.
And so while they're unloading, trucks are piling up behind, and now it's time for this particular truck number 3015,
Mhm.
to move off the job site,
Right.
he having been fully offloaded.
Right. And to help facilitate that process for this particular truck, we had two swampers who, in the case, were referred to as AC and HC. And these were actually brothers, HC being the more junior employee, and was actually his, I think he was on the job for only less than 2 months. So
Yeah.
he was under a mentorship program that was facilitated by Hall with HC, his brother.
So his brother was assigned to him to be his mentor,
Mhm.
and AC's job was to stay close to HC, do everything that HC does, follows instructions, and learn how to do the job safely by job shadowing, essentially, for the first couple of weeks, staying close to his mentor, HC.
Mhm.
These initials, by the way, are anonymized in the opinion to anonymize the individual employees out of respect for their privacy. So we'll continue that.
Right. And then, so during this process, AC and HC were walking with their backs to the truck as it backed up, providing spotting. And
And that is a classical error
right.
in safety procedure. They should always, even on the face of Hall Trucking's safety protocol, written safety protocol, as well as just as a common occurrence, they should always keep their face to the truck in motion so that they can continue to spot it and know when to move out of any zone of danger.
Right.
But at this particular moment, for whatever reason, AC and HC were walking with their backs to the truck, and the truck still continued to move backwards. So two things should have happened, not just one error, but two. They should have been facing the truck that was in motion, and the truck should not have engaged in motion at all if it spotted that one or both or either of the swampers were not in position and facing the truck and keeping their eyeballs on the truck in motion. So those are really two compounding errors.
Mhm. Right. And the result of the errors was unfortunately and tragically AC being hit by the truck as it was backing and eventually leading to his death.
The truck was backing up into a choke point. There was a truck right behind it, and that truck behind it moved backwards a little bit to give the truck 3015 a little bit more space. The truck 3015 moved backwards and to its right, or passenger side, which is where AC was standing and was invisible to the driver of the truck.
Mhm.
Uh, HC should have spotted that there was a pedestrian obstructing truck 3015's path, but didn't. Instead, HC signaled the driver of the truck to continue in his path, essentially waving an all clear when HC didn't actually have a full line of sight to the full range of motion of truck 3015.
Mhm.
Not having seen the entire path of motion, HC nevertheless waved him on, and in doing so, waved the truck into the path where his own younger brother was standing.
Mhm.
And as you say, that had an unfortunate consequence. Truck 3015 backed into AC, striking and killing him.
Mhm. And I think we can say that we have a pretty accurate idea of what happened in this case because these events that you described, Manish, were captured by the dash cam of a truck that was parked facing this incident. So OSHA had a pretty clear idea of how this accident took place.
Right. There was very little dispute on a lot of the facts. Indeed, the parties stipulated to a lot of the
Right.
facts and stipulated to these facts as well because they were caught on the dash cam. Here's another interesting fact. You mentioned the camera. This truck had backup cameras as well.
Mhm.
Uh, Unfortunately, at that time of day, the sun glare hitting the rear camera was just positioned just so that the driver was not able to see anything out of his monitor through the backup camera.
Mhm.
And so it was essentially rendered inoperable. And he was even more dependent on a informed, considered all clear signal from HC.
Mhm. So once after the events happened involving AC's death, the next day, an OSHA compliance officer came onto the site as a standard protocol and conducted an inspection. The inspection included a site walk around. They actually used an aerial drone to get a better idea of how the site map. They conducted employee interviews and reviewed the training and safety records that Hall provided.
This is a relatively thorough investigation. They came to the conclusion when they looked through Hall's written policies that there was an extensive protocol for safety and health on the job site. Not a lot that described traffic safety. The traffic safety section of the written plan, uh, well, it mostly dealt with over the highway traffic safety and very little to do with the ground operations. Then they interviewed several workers and asked them whether they were familiar with the contents of the safety plan, whether they'd had any training, and whether they understood their training as with specific respect to ground safety.
Mhm. And the another practice that was common at Hall was that before each morning of work, the pusher, in this case Corditz, would leave a safety meeting with the swampers that in that he testified outlined the hazards that these folks would face each day and sort of what the plan was for that particular day. And this is important to keep in mind because one of the key arguments that Hall makes in its defense later on, which we'll discuss, is that the nature of this job, of this kind of job site, is that, Manesh, like you mentioned, there's a lot going on. It's dynamic, it's changing. It's not a fixed, it's not a floor plan and an assembly plan. Things are always moving, things are changing. So Hall would use these safety meetings to sort of instill what it believed to be the hazards that would be faced by workers each day.
Right. And when Geertz was interviewed, he was asked about certain elements of that written plan. He was asked about those morning tailgate meetings. He had a very poor recollection of the particulars in the safety plan, and so did the owner, Mr. Hall. So OSHA, having conducted its inspection, its visual inspection, as well as interviews of employees and a review of the written safety plan and these morning tailgate meetings, safety meetings that you referred to, Ben, they issued a citation, a single citation item under the general duty clause, alleging that Hall Trucking had failed to adequately implement measures for struck by hazards, such as the one that AC died by. So the general duty clause, recollect from many of our previous episodes of the OSHA 3030, when OSHA issues a citation under the general duty clause, as opposed to a citation under a specific OSHA standard, they have a different set of elements that they have to establish during the carriage of their case. The first one they have to establish is that there was a condition that exposed workers to a hazard.
And that the second element would be that the hazard that the workers were exposed to by this condition was recognized in the employer's industry.
Right, either that the employer themselves recognized the hazard or that it was generally recognized by the industry that the employer participates in. And then the third is that there's a likelihood that that hazard could lead to serious harm or a fatality.
Mm-hmm. And the fourth element, which I think was one of the main elements at issue in this particular case, was whether there was a feasible means of correcting the hazard to protect workers from it that the employer could have implemented.
Right, that's right, Ben. And the judge spent a considerable amount of his written decision, discussing that as well. So when they issued the citation, the agency alleged that Hull Trucking had exposed employees who were pedestrian on foot to the hazard of being struck by mobile equipment, trucks or other equipment that were on the job site. and that Hall had failed to abate that hazard because it did not have an adequate and adequately disseminated internal job site traffic control plan.
And the reference point, when going back to the first element of a general duty clause citation, is OSHA alleged that the proper industry to reference here was trucking. And in the trucking industry, provided statistics from NIOSH, provided things from the North Dakota CDL manual that Hall would have been exposed to that all make clear that um, uh, workers face struck by hazards on trucks that are backing on job sites. So that was their angle to it. They wanted to say that the trucking is the industry of reference, and Hall, as a trucking member of the trucking industry, should have known about this kind of hazard.
Hall contested that point and said, no, we think we're part of the oil rig
Mhm.
erection or construction industry. Uh, it didn't make much sense to the administrative law judge. He believed that it doesn't really matter what material is being hauled on a truck. Once you arrive at a job site, unload or load and depart, the activities, the hazards associated with that activity are the same, regardless of the material. And so another source that OSHA was able to point to was the road construction industry's safety protocol for job sites, because that also involved large trucks, often large flatbed trucks, unloading material, finding safe places to park the vehicle and unload and offload, and then depart. And that the traffic control plans in those road construction sites seemed to be an example of means to effectively abate struck by hazards that demonstrated not only the effectiveness of their plans, but also the feasibility that they were implementable by an employer. So the agency pointed to those kinds of industry standards that are already in place and well known, and the administrative law judge credited the agency's evidence on that point.
Right, and on the point of economic feasibility, what OSHA alleges that these internal traffic plans they weren't particularly expensive to implement, and in fact later on we see that Hall admitted that costs of implementing something like this wasn't an issue for them.
Indeed, that's right. The judge said that most of the equipment, at least that would have been necessary to implement the plan, Hall Trucking already had.
Mhm.
That wasn't really the problem with why Hall Trucking's plan was ineffective.
Exactly. So when we get to Hall's defenses, Manish, like you mentioned before, um, one of the first points that Hall makes is that they were a member of the oil and gas industry, not of the trucking industry.
But they didn't really explain how their traffic safety plan would have been any different
Right.
in the oil and gas
Yeah.
industry. They simply said, in the oil and gas industry, everything's ad hoc. We do things based on how every job site is different. And so every day it's different. And
Mhm.
so we just every day have to make sure we run things safely on an ad hoc basis. That, I think, was the reason why they wanted to section themselves off into the oil and gas industry rather than the trucking industry. Say what you will of the fact that the name of the company is Hall Trucking Incorporated.
Right. The other point that Hall made, one of the main points that it made, is that its existing safety program that it had, the safety measures that it had in place, were indeed sufficient to abate the hazard of backing posed to ground workers. Before, Manish, you mentioned the backup cameras that Hall had actually recently installed in their trucks. That was one thing. They also had backing alarms on trucks. They mentioned that they had written policies. They had job mentoring, like we saw between AC and HC. They had some orientation training. So they made the case that these things all collectively provided a sufficient abatement, and the AC incident was an anomaly.
Well, that's right. And they also put on a argument that when they had a swamper in the back and the swamper was giving directions to the driver, that there was no way to prescribe a specific path of traffic because, as we said earlier, the construction The nature of construction is that the arrangement of vehicles and the location that the materials need to be dropped in is changing on a daily basis. And so it really requires that the pusher, Gertz, be constantly arranging the arrival and departure of trucks and the location of their offloading in a manner that on a day-to-day basis would change, so that he would arrange them on a day-to-day basis in a way that he thought was the safest. So it really required nonstop vigilance by the pusher, Gertz, as well as the swampers, AC and HC in this case, and that they never made any errors.
Mm.
That's the system essentially that Gertz was testifying was the system they used on a daily basis.
Right. And it's a system that was commonly used in at least what Hall indicated. That was what its peers in that same industry used.
That was their allegation, their testimony, but they didn't put on evidence from
Yeah.
other peer groups or any industry expert, and that was pointed out by the ALJ.
Mhm.
So when the ALJ reviewed all of this and reviewed Hall Trucking's defenses, the judge agreed that OSHA had identified correctly the right industry, that it was trucking, and looked to the actual activity that was being performed by Hall Trucking and said that the activity was the same without respect to the type of material being offloaded, that in that particular case, oil rigging equipment, and that it could have been any material, and the challenges of a job site, construction job site of any kind, are the same regardless. And so that Hall should have been measured in its safety and health plans or its ability to recognize a hazard with respect to peers within the trucking industry and not within the oil drilling industry.
Mhm. What I also thought that was interesting that the LJ pointed out was that um, he wasn't so convinced that even if the oil and gas industry was applied, that Hall would still have an acceptable idea, would not be aware of this kind of hazard. In fact, the ALJ pointed out to an OSHA e-tool for well drilling and servicing, and also a trade association document for drilling contractors that all pointed out the hazard posed by backing trucks.
Yeah, and this is why that's right, exactly right, Ben. And this is why I said I didn't really see any argument on the part of Hall Trucking that the standard would have been any different had it been categorized as an oil and trucking firm. Indeed, Gertz, the pusher, the supervisor, testified that he had recognized backing up, trucks backing up as a hazard to pedestrian employees. And so it really wouldn't matter as long as he has a recognized hazard as the supervisor on site, then it doesn't matter whether one industry recognizes the hazard and another doesn't. Indeed, as you state, both industries had papers published within the industries identifying moving trucks and particularly backing up trucks as hazardous. And so that whole debate, that defense wasn't a pathway that would have led them anywhere differently.
No, I think that's exactly right. Um, and then with respect to the existing safety measures and the program that was in place at Hall, I thought that ALJ had a pretty powerful quote here when he said that the existing program was incomplete at best and merely an unrealized, unimplemented paper program at worst.
His complaint there was that not only was the written plan very long and spent very little of its time dedicated to pedestrian safety at the job site, but much more importantly, I think the most important part, the judge said it didn't look like it was communicated to anybody that mattered. Gertz couldn't testify accurately as to the contents of the written safety plan. Hall couldn't testify accurately as to the contents of the safety plan. And when the compliance officer interviewed non-supervisorial workers, they testified that they were unaware of the policy, that they were given, I think, something like 15 minutes to study a 70 or multi-hundred page document. I forget the exact length. And that the training didn't cover the specific subject matter. Essentially, that although there was a written plan, nobody was really aware of its contents. It was, as the judge remarked, a plan that was just written and put on a shelf, and that was not enough to the judge's mind to qualify as an internal safety program, a living, activated safety program on site.
Exactly. And I also think that to that point, Manesh, their Hall was unable to provide any records of any disciplinary actions under that plan. If there was, in fact, a living and breathing plan that was in place, you would think that Hall would have some evidence of there being discipline enforcement of it.
Well, yeah, and I think there was a little bit of conflating that point, which is an element in the unpreventable employee misconduct defense, with the general duty clause, and I objected to it being discussed. But it does occur to me that maybe one of the reasons why the judge raised it was if you start disciplining on a particular element of your own safety plan, you'll find out pretty quickly whether your workforce had properly learned and been trained on that element of the safety plan. If, when issuing internal discipline or correction on a specific requirement, employees are clearly unaware that it was required of them, you then quickly find out that you hadn't communicated it effectively to begin with. And so perhaps that was what the judge was driving at. And if that's so, I think it's a fair point that the absence of any internal coaching, counseling, or discipline or monitoring is evidence that maybe it hadn't been properly communicated to the employees, that they hadn't been properly trained.
Right. So then we can also get to existing safety measures. Like we mentioned before, Hall did have safety measures in place, the backing cameras, but Manesh, like you mentioned, there are problems with this. The backing cameras were ineffective at direct sunlight. With respect to the backing alarms on trucks, the ALJ pointed out how, on a job site like this, you can imagine that sound is prevalent throughout with how many trucks are moving in and out. Having a beeping sound on a backing truck wasn't necessarily something that would be of much help. And they also addressed.
Well, what Hall testified to about the backup audible signal is that people just tuned it out because it was going on nonstop on the
Yeah.
job site. Trucks were backing up all over.
Yeah.
And so it was easy for workers just to eliminate that sound from their consciousness and to just tune it out. I don't know why they would have pointed that out, what their point was, except to say that they were relying on the importance of the pusher to do ad hoc safety administration.
Mm-hmm. And then the ALJ addressed the point of the technological feasibility of having an internal traffic plan in place at the work site. Like we mentioned, Hall said that it wasn't feasible because of the dynamic nature of the work site. But in fact, OSHA, which proved to be the key point, OSHA proffered the expert testimony, which stated that, in fact, these plans are designed for dynamic work sites. And the ALJ found that testimony to be persuasive.
That's right. The agency put on an expert witness, and the only four witnesses to testify at the hearing were the owner of the company, the pusher, Gertz, this expert witness, and the compliance officer. And so each party put on two witnesses, only one expert witness, and that was on behalf of OSHA. And he testified that there were a lot of elements of a adequate safety plan for ground sites struck by hazards that were in place at Hall. And there were a lot of pieces of equipment for safety that were in place at Hall, like front and back cameras, audible warnings, etc. That the problem was that that they all need to work in concert, and that the comprehensive safety plan needs to have all of its elements in place in order for it to be effective. And one of the elements that was not in place at Hall was the communication of the plan to the workers. Another one was training, adequate training for both supervisor and swampers, as well as for drivers. Another element was that drivers should be participating in these morning safety briefings. In Hall's case, they were not, because they were usually on the road. And that all of these have to be working together to make for a comprehensive safety plan. And that's how you reduce struck by hazards on a job site. That was the testimony of the expert witness that was put on by OSHA. I thought that was an interesting element that the judge keyed in on, that there was no evidence to the contrary. Hall didn't put on an expert that actually supported Hall's proposition that other employers do the same thing as Hall. Hall didn't put on any expert testimony to suggest the adequacy of its written plan, or that there were any questions about feasibility of implementing any additional elements that the agency had alleged should be in place. So it was really a asymmetry of expert testimony. I think that was probably the most persuasive to the administrative law judge. Okay, so that was the case and that was the decision. Why don't we talk about what we think members of our OSHA 3030 community should do in light of this decision?
Right. I think that the first important takeaway is just to keep in mind that um, industry custom is not always going to be an effective defense. Just because other people in your peer group are doing something doesn't mean necessarily that OSHA is going to find that to be an acceptable, healthy and safe practice.
Right, Ben. And I think even more importantly, just alleging that this is the industry custom, just testifying that everyone else is doing the same is going to be even less adequate
Yeah.
as an effective defense. I mean, at the very minimum, if that's truly the case, then the employer ought to bring on witnesses from the industry
Mm.
to establish what the industry custom is.
Right. And then the second point would be to, like we discussed, make sure that the written policies are effectively communicated, understood, and enforced. Those are really three critical pillars. Otherwise, like the case discussed, these written policies can just be considered sitting in a cabinet somewhere and unaware by actual employees.
That's right. I think to begin with, the development of the written safety plan ought to be vetted by an outside expert, a consultant, an OSHA attorney. And one of the things I would certainly do if I were taking a look at a corporate safety plan on a specific subject is to investigate whether there are industry standards out there, consensus standards, for example, out there in a particular industry, and then make sure that all those elements were considered as to whether or not they should be in the company's safety plan. Then, as you say, that training, the training of the employees has to be regular, frequent. New employees have to be trained. There should be records of the material that was in the training content and records of every employee who took it and how many times they took it. And then there should be at the end of the training session testing for comprehension, and then written records of the test, comprehension test.
Exactly. And I think also to that end, ensure that while employees are being tested, ensure that supervisors are also educated about the standing policies of the company, not only to help train the workforce, but like in this case, we saw that the ALJ noted how the representatives of Hall struggled to recollect what their safety practices were and found that to be unfavorable in their case, right?
That's right. And Ben, as you mentioned earlier during the program, there's no question that a record of monitoring and then corrective action or disciplinary action should be documented and preserved so that employers have the ability to raise the defense that they took this particular requirement seriously and that maybe it sets the stage for an unpreventable employee misconduct case. Indeed, there is evidence that HC should have checked that the pathway for the truck was clear prior to just waving the truck on and giving them the all clear signal so that the truck mistakenly believed that there was no obstruction. Uh, I think the driver also should have stopped if his camera was uh, rendered inoperable by sun flare and informed the flagman HC that he was 100% dependent on HC signaling. The last thing I'd say is that when mounting a defense, if an employer wishes to present a defense, that they have to map all of their facts to each of the elements that are necessary to mount an effective defense. And they have to identify where there are gaps in their evidence, and they may need to identify whether or not, in doing that, undergoing that process, identify whether or not an expert witness is necessary. This is critical to being an effective OSHA defense. And I think that the counsel that any employer receives in considering whether to defend in the first place, whether to contest a citation, and then when doing so, how to mount an effective defense, has to go through this process. I don't think that this was a process where I think there was a gap and a missed opportunity for Hall Trucking in putting together a defense that would have been perhaps more credible than the LJ found their defense to be. Well, that's today's OSHA 3030. Ben, thank you. We'll be back again on October 22nd at 1 p.m. Eastern, always on a Wednesday, always at 1 p.m. Eastern. We have sister programs, the Reach 3030. The next one's October 1st. The Tosca 3030, also October 1st, 10 a.m. and 1 p.m. respectively, also Eastern Time. We're thankful to you for spreading the good word about those programs and the OSHA 3030 to at least 3 other people inside your company and friends and colleagues at other organizations so that the word of mouth about the OSHA 3030, Tosca 3030, and Reach 3030 continues to spread so that we can do this maybe for another 13 years. We do this complimentary to you, friends and clients of Keller and Heckman. And all that we ask in return is that you continue to share with 3 new people every month the invitation that we send to you by email when you're about to register for the next program. If you're doing this by podcast, then share the podcast with your friends. No need to register. We also present the slides, the video, and sound on our website, khlaw.com/OSHA 3030, so that you can catch it housed on YouTube. You can catch it on our website, all of our prior episodes as YouTube videos. On behalf of Ben Idzik and myself, Manesh, Rath, thank you for joining us on this OSHA 3030. And I want to thank not only all of you in the OSHA 3030 community, but our staff here at Keller and Heckman who help produce this show every month and do just a great job. We're thankful to them. So thank you all, and we look forward to seeing you again next month. And until then, stay safe.